then it's unconstitutional. It can be unconstitutional if the state got it. Imagine we got
Members, help us welcome some young people here today advocating for sickle cell, the Baton Rouge Sickle Cell Anemia Foundation. And we have in the room Tamika Tate, Harley Roller, Dolores Moore, and Shantae Lathers. They've come and gone. We'll let them know that we recognize them, and certainly we support. And certainly they're standing right in the back. And certainly we fight for sickle cell. We want to help break the cycle as well. And thank you very much for participating at the Capitol.
Yeah. I need to call. You need to get me a couple of them. I'm gonna tell her I mean. No, but I need it so I can tell her that I'm getting a phone call. What's his ass? That's recorded. Let me come in here. You can build off that him. Yeah. All people or something. He must be. Is he with Democrat? He's going to add one more thing to make when you file the petition. He wants the court to have he wants to have a hearing to determine public purpose, which the state don't have. I'm going to try to take it out later on that. We got to get from point A to point B. I got to get it out of this death trap. Y'all got me.
Let's just do that. Okay, we ready?
Yes, ma'am.
Okay.
On page 2, delete lines 12 to 14 and insert in lieu thereof, on the ground that it is not for a public purpose, a copy of this part must be enclosed with the letter of notification. Period. Once the petition is filed, the court shall conduct a declaratory hearing to determine whether the ordinance adopted by the parish council satisfies the public purpose as required by the Constitution.
Would it be permissible to put a time frame to make them hurry it? It would make the parish hurry it, and it would help the people, wouldn't it, Senator Cortez?
Do you want to put so many days? The court shall conduct the hearing within so many days?
60 days, maybe?
Senator Cortez?
I would think so. Again, now we're dealing with forcing the courts to do something that, I would like it to be, because I think that's the whole point, is that you have potentially an objection. And so we would like to hurry it, but again, no one here from the courts to suggest that they could. You're a lawyer, you can tell me. Is that reasonable?
60, well, I thought of 30 first, but I think 60 is reasonable because the courts always have 1 day a month at least back home. They have, each judge has in each parish 1 court date a month to hear hearings such as this.
Okay, we can add the 60.
Dawn, can I ask a question? Is there notice to the property owner under your scenario right there?
It's after the language in the bill that requires notice.
Okay.
This language goes in.
So, but I mean, when the court has this declaratory judgment hearing, he's got to notify the property owner?
I don't have that in here.
No, I didn't hear it either. That's my concern. Because the judge could just have that ex parte hearing then on whether it's a public purpose, again, without the landowner being involved in presenting evidence that it's not.
Do you want to require notice to the landowners?
Well, I think that's the whole point. Yeah.
Yeah.
And the 60 days is so that they can do their landowner homework.
That wasn't in there, but that's fine.
A copy of this part shall be included with the letter of notification. That's the letter of notification that goes to the landlord. Then it'll say, I think that's earlier too, it says certified return receipt. And it says, once the petition is filed, the court shall conduct a declaratory hearing with notice to the landowners within 60 days to determine whether the ordinance adopted by the parish council satisfies the public purpose required by the Constitution. Then the second amendment will go into page 3, line 14. This is the section of the bill that talks about what is required for the parish to file with the court. And on page 2, line 3, it's going to be an itemized statement of the amount of the appraisal but somehow I got to insert 2 required appraisals, 2 appraisals by certified or accredited appraisers, whatever their licensure is. And the money estimated is going to include the appraisal plus damages. And then we're going to change the word, it shall be signed by those who made this is on line 16, the appraisal instead of the estimate.
Damages, so what you talking about?
Well, that's what you have in here, the owner's loss for the taking or the damage or both.
Okay.
All right. So I'm thinking you're appraising the land, and it may be
And
you might have
damages.
a renter or some kind of...
Yeah, it could be a yard could be torn up or whatever. Okay.
And then also estimate is on page 3, line 23. So that's going to be the amount of the appraisal, and then we can say appraisal plus damages, the higher appraisal, plus damages to be deposited in the registry of the court.
Okay.
Okay. Does everybody understand the amendment, or does anybody have questions on the amendment? Okay. Senator Cortez?
Yeah, this is an attempt to try to find some common ground between the two sides. I think that Mr. Hayes brought some valid points to the table, and I hope that I'll move adoption on these amendments. And
Okay. Is there any objection or any questions first to the adoption of the amendment or toward the amendment? Okay. Is there any objection to the adoption of the amendment? Hearing none, the amendment stands adopted. Okay. So we have the bill in the posture. I would like to hear from the opposition again to see where they are now.
He may be wanting a green card now though with all these amendments. No.
No, ma'am. We still have the problem with the quick take and not following the current expropriation law, which is under the Constitution. I mean, we didn't just satisfy all the constitutional requirements with those amendments. So, I mean, we're still opposed to the legislation. I've seen no exigent circumstance of why the parish needs to go to a quick take rather than an expropriation ordinary authority. In all the statutes that I've looked at, Youngsville had an issue, Lafayette had an issue, Terrebonne needed to create a levee down there, that's why they did it. There were all these exigent circumstances of why we needed to do quick take instead of the ordinary process. I've heard nothing except that a property owner fought for his property rights, which by law he's entitled to do. That to me does not rise to an exigent circumstance on why a parish governing authority needs quick take authority to take somebody's property versus following the ordinary expropriation process which they have right now.
Okay. And the gentleman that spoke that had the sewer business, he left. Okay. You have, I'm going to read into the record the cards in support. Tommy Martinez, Ascension Parish, Senator Troy Brown, Benny Johnson, Ascension Parish, O'Neill, I can't read the last name, but from Ascension Parish, Chris Leon from Ascension Parish, Lore, okay, and Chris Guidry from Ascension Parish, and in opposition, Tom Perrette.
Pertuit, that's the
Okay,
man.
I used to be able to read lawyers' writing, and I'm getting older. I can't read it anymore. Alicia Duhan from Adams and Reese, Rob Rieger from Adams and Reese, Kevin Hayes, Louisiana Landowners, and Matthew Spradley with the American Sugarcane League. And you have the right to close, Senator.
Thank you, Madam Chairwoman. I'll be real quick, but this is not unconstitutional. It's never been ruled unconstitutional. Actually, there was a case, I think it was in 1977. It went all the way,
Goldencraft versus State of Louisiana Department of Transportation.
all the way up to the Louisiana Supreme Court on quick take. Is not unconstitutional. So that's, you know, I've been around here just a few years, but when people start yelling unconstitutional, it's usually because they're just against the bill. But we desperately need sewer in Ascension Parish. You know, I was talking to Mr. Bell earlier. We all got sewer running in our ditches. I know people that live in big cities don't understand it, but it's not the nicest thing to be cutting grass and have to deal with sewer in your ditches. And as the fastest growing parish in this state, there's no reason that we 20 years behind. It's not your fault. It's not our fault. It's just something that should have been done years ago, and we got to get it taken care of. And without this ability, I see no way to do it. It's something that's got to be done, and I'd ask that you move favorable. This issue has been going on for about a month with this bill. I've been working with people from my parish. I've been working with different groups to amend this bill. Mr. Hayes has never asked me to amend the bill, and then came today with some problems. You saw that I'm willing to work with anybody. I didn't mention earlier, but it takes a 2/3 vote of our council to use this procedure, which I didn't have to put in here, but I put in here because I wanted to give the citizens of my district and the parish confidence that they're not going to be abusing this process. And that's my intent. I think it's a good thing. Our whole delegation supports it, and I appreciate your favorable consideration.
Okay, we have, I think, given a fair hearing to Senate Bill 703, and we've amended it. What's the pleasure of the committee? Okay, I don't hear a motion from the committee. You move, or you don't move? Okay, and I object to that, and I substitute to defer the bill. So we'll take a vote on the last amendment, unless there's no objection.
The amendment, or?
Is there any objection? Hearing none, then that bill is deferred.
Okay. Thank you.
You're welcome. I think that finishes our schedule. You guys did a great job as usual, and we want to thank our Madam President Pro Tem for being in with us, or we would not have been able to have a meeting today. Oh. Anyway, she's here today, and we're glad she's here. Thank you, and thank you, ladies, for coming today as well. And I'll take a motion for adjournment. Senator Broom, Senator Mills, and Senator Cortez moves that we adjourn. Thank you.